What if every child under 16 in Australia suddenly lost their Facebook, Instagram, TikTok, and YouTube accounts, not because of parental rules, but because it's now against the law? That's exactly what happened in Australia in December 2025 when the Online Safety Amendment Social Media Minimum Age Act came into force, banning under-16s from holding social media accounts. It's being watched around the world as a bold experiment in regulating tech, but it's also sparked legal challenges and heated debate. The main criticism is that it's a blunt instrument that will not fully solve the problem it tries to address. The law only shifts risk elsewhere, creates false safety, and avoids deeper reform. In this video, we will explain how this law was enacted, why the minimum age was set as 16, what the public debate is really about, what it means for families and tech companies, and whether other countries could or should follow Australia's lead. I will also address a misconception and explain why the law does not function as a penalty to parents or children. Now let's dive in. The policy didn't come out of nowhere. It was introduced in Parliament as the Online Safety Amendment Social Media Minimum Age Bill 2024, amending the existing Online Safety Act 2021. The bill was introduced on 21st November 2024 by the Federal Minister for Communications, Michelle Rowland, on behalf of the Albanese government. Rowland was previously a senior telecommunication lawyer at Gilbert Tobin, and she has served as the Attorney General since May 2025. The legislative journey was surprisingly fast. The bill was introduced, referred to the Senate Environment and Communications Legislation Committee, and passed on 29 November 2024 with relatively few days of debate, indicating a compressed process. It amended the Online Safety Act to require that age-restricted social media platforms must take reasonable steps to prevent Australians under 16s from having social media accounts, or face civil penalties of up to $49.5 million. This is calculated based on the 150,000 penalty units, which means the future penalty cap could even be higher. The Minister's Office and the Prime Minister Albanese frame it as a key child protection reform, building on the broader Online Safety Act that consolidates Australian online harm regimes. So why the minimum age is set as 16? The choice reflects a mix of child development research, government consultation, and public campaigns. Government and eSafety published research papers reporting rising concerns about online harms among young users, including cyberbullying, image-based abuse, compulsive use, and mental health risks. They argue that for many young ages 13 to 15 are especially vulnerable, and that delaying account access could reduce exposure to harmful design features and exploitative algorithms. Age 16 also aligns with other legal thresholds in Australia, such as age of consent in some privacy laws and eligibility for certain rights, making the choice politically and legally convenient. Some research cited by the government suggesting adolescent participation in social media correlates with lower life satisfaction at certain ages. Evidence from age assurance technology trials also informed that platforms could already detect underage users, and it will be practical for platforms to enforce an age floor. Now let's look at the public debate and the key factors in dispute. The policy won broad public support. Polling suggests over 2/3 of Australians back the idea of a minimum age for social media, especially parents of younger children who see online harm as a pressing mental health issue. Supporters include Prime Minister Anthony Albanese, senators like Maria Kovacic, Dan Tan, Dave Sharma, and Jenny McAllister. They argue the law will reduce exposure to harmful content, online grooming, and compulsive use during key developmental years. Many parents feel overwhelmed and want government standards to help them protect children's well-being. During the Parliament debate, Michelle Rowland illustrated evidence of widespread harm at the vulnerable age. She told the House that almost 2/3 of Australians aged 14 to 17 had encountered extremely harmful content, including suicide and self-harm, and that 95% of caregivers described online safety as one of their hardest parenting challenges. Multiple members of Parliament across parties echoed a shared premise. Parents cannot solve this alone. If one parent says no social media, their child is socially isolated, unless everyone says no. The law is framed as restoring fairness by setting a social baseline so parents are not left negotiating alone with billion-dollar platforms. Rowland explicitly described the bill as letting parents know we are in their corner, rather than punishing families or children. Critics didn't deny harm. They challenged whether this solution is fair, proportionate, or effective. The opposing parliament members include Senator Sarah Hanson-Young, Senator David Showbridge, Monica Ryan, Stephen Bates, and Elizabeth Watson-Brown. During the parliament debate, a recurring criticism across Greens and Independents was procedural unfairness. This is particularly the case considering the bill was introduced and passed within days. Senator scrutiny was compressed, and many submissions were logged with minimum time for analysis. Several parliament members pointed out that they were unimpressed by this kind of legislate first, explain later approach. This mattered because the bill delegates significant detail to future rules and guidance, particularly around what counts as reasonable steps and which platforms are in or out of scope. Critics argued Parliament was being asked to approve a framework without even knowing how intrusive or uneven implementation might become. One example is that, as reviewed in the Digital Industry Group's letter to the Parliament, the government's impact analysis for the new rule contains a 2022 study co-authored by Professor Andrew Schabelsky. But Professor Schabelsky posted a linking article in November 2024 stating that the government has misunderstood the purpose and findings of his research. Another fairness concern was that banning accounts may only create a false sense of safety and displace harm rather than reduce it. Speakers such as Greens and crossbench parliament members warn that children may migrate to smaller, less regulated platforms. Vulnerable groups including LGBTIQ, regional kids, and those relying on online peer support could lose access to safe communities. The critique leaned heavily on the findings of the Joint Select Committee on Social Media and Australian Society, which had previously warned that bans do not address algorithmic design, recommender systems, or engagement-maximizing business models. Perhaps the sharpest fairness anxiety concerned privacy. Platform must prove age, who bears the privacy cost. There was bipartisan concern that age assurance could drift toward government ID checks, facial analysis, and centralized data collection. The fairness concern here is that a law designed to protect children might normalize surveillance of everyone. Tech companies argue the laws are vague, what constitute reasonable steps, and may lead to invasive age verification practices like biometric scans or document uploads. Organizations such as Reddit and rights groups like Digital Freedom Project have launched legal challenges in Australian High Court, claiming the new law could infringe on implied freedom of political communication or other constitutional rights. We will keep a close eye on Reddit's action in High Court, so make sure you follow us so that you don't miss the latest update. What does this law mean in practice? The age-restricted social media platform has a broad definition. This will at minimum include TikTok, Facebook, Snapchat, Reddit, Instagram, and X. These services will be required to take reasonable steps to prevent persons under 16 years of age from creating or holding an account. However, young people may still get access to some platforms if they are designed to enable young people to get the education and health support they need. For example, Reach Out's peer chat, Kids Helpline, My Circle, Google Classroom, etc. Also, the law does not criminalize children or parents. Instead, it puts the obligation on platforms to take reasonable steps, like age verification, to prevent under-16s from registering or maintaining the accounts. That means even if there is any non-compliance, children and parents commit no offense. The legislative intention is that the age threshold is presented as a protective boundary, not a moral judgment. Rowland repeatedly emphasized during Parliament debate this distinction. The law regulates the login, account-based environment where algorithmic amplification, persistent notifications, and behavior nudging occur, rather than passive access to information. That distinction underpins the government's claim that the law protects without isolating. So what's the impact to each individual? Parents may welcome a legal backstop against early social media exposure. Children under 16 lose the ability to hold accounts, but can still browse public contents, and some will find workarounds. Media companies must implement age verification tech, from AI face estimation to document checks, otherwise they will risk huge fines. Regulators, in particular e-safety, will oversee compliance, consult widely, and may update rules or extend the platform list. Schools and educators are adapting policies around communication and online engagement too. Australia is the first country to implement such a broad legal minimum age on social platforms, even when China has introduced rules since 2021 to restrict teenagers' gaming time to an hour. On Fridays, weekends, and holidays, they do not go that far. Other jurisdictions, including UK, Denmark, Norway, Malaysia, and EU states, are watching closely and considering similar ideas. What's impressive is that this move is an outcome of collaboration by major Australian parties. That itself can hardly be duplicated in other countries. So it will be interesting to see if the bill will be welcomed by other voters globally. Legal barriers elsewhere include free speech protections, human rights law, privacy limits, and constitutional constraints that may not exist in the same form in Australia. Also, enforcing age restrictions across global tech services is technically and legally complex. Expecting those media giants will fight back. Now let's conclude the video. Australia's minimum age law for social media is ambitious, controversial, and likely to shape the future of online safety policy globally. But as mentioned by Roland, the bill does not provide the magic pill to resolve or eliminate every harm children face online. And we also acknowledge that harms don't simply switch off on a child's 16th birthday. Legislating a duty of care is only the first step. It means that telecommunication companies can't set and forget. Instead, they will have ongoing obligations to identify and mitigate potential risks when technology evolves. By regulating the act of having an account as opposed to accessing social media more generally, Australia is to strike a balance between protecting young people from harm while limiting regulatory burden on the broader population. Do you think it's fair to bar under-16s from accounts? Are age checks an overreach or a necessary protection? Or do you think that since there is no penalty, children that are more sophisticated in new digital equipment will just slip through via facial estimation or use VPNs instead? Let us know in the comments below. Don't forget to like, subscribe, and hit the bell for more in-depth legal explainers. Thanks for watching. See you next time.